Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 177 of the NCDWI Guy podcast. On today's episode, we are talking about DRE, drug recognition expert opinion. We're going to be kind of walking through especially a post-hoc DRE opinion. So effectively, DRE is not involved at all in the roadside investigation, isn't involved in doing a DRE opinion back at the detention center or jail or later at the hospital, wherever kind of the continued investigation occurs. So there's no DRE involved at the time of the charge or at any relevant time to the charge, but a DRE comes in to offer testimony at trial. We're going to specifically look at this in light of two recent cases. One that was issued this morning, State versus Williams. That is a North Carolina Court of Appeals case. That's number COA 22-1015, as well as State versus so that was State versus Williams, as well as State versus, let me pull this other one up real quick. Lewis. We had talked about State versus Lewis back on episode 167, the 2023 case law, DWI case law update. State versus Lewis is 2022 NCCOA 887, and that was decided back in December of 2022, so less than a year ago. And again, State versus Williams was decided today, or at least issued today. So effectively, both of these are unpublished opinions, so limited authority value in terms of citing these, but there's a little bit of an odd kind of dilemma in terms of interpreting both of these together that I think is favorable to the defense. Also, recently we had Anthony Palacios, SFST expert and DRE expert. I mean, just a phenomenal resource. Anthony is to the DWI community, but he came on back on episode 144 to discuss the value of a DRE in a drug impaired driving case. If you have a drug impaired driving case coming up for trial, go check out that episode with Anthony Palacios. Anthony, again, will be speaking at this year's Freedom Fighter Summit on being the SFST expert in the courtroom. Will be available for a longer form conversation for anybody that can attend the summit, but he is an absolute guru and such an incredible resource to have when it comes to DRE training, DRE evaluations that are given anytime that you have a case involving drug impaired driving. He can offer an evaluation. So certainly reach out to Anthony if you have any issues finding him. His contact info, please reach out to me. I'll be more than happy to share Anthony's contact information. But if you're just trying to find him online, you can just type in his name. His website is impaireddrivingspecialists.com. That's impaireddrivingspecialists.com. So go check him out. But today we're going to be talking again about kind of the post hoc DRE testimony. And so effectively, again, we've got a fact pattern, let's say, where you have somebody that is stopped, goes through a checkpoint, gets into an accident, whatever the police contact is. Police on the roadside are not DREs. Maybe has limited training, might be all the way up to an A-ride officer, but has limited or does an evaluation, whatever that looks like in terms of just normal field sobriety testing, or maybe doesn't do any field sobriety testing, but no drug recognition expert is involved at the roadside. No DRE is either available or ever contacted. Person is taken into custody to the hospital. Again, no DRE is involved in doing a evaluation of the defendant at any point after the defendant is arrested, prior to them being released from custody. And so you basically don't have a DRE involved in real time during the investigation or immediately after arrest. But the state calls in a drug recognition expert to testify at trial regarding kind of signs and indicators of impairment related to specific drug categories, or reviews the kind of real-time evidence that is given. And given the opinions that are issued in State versus Lewis, as well as State versus Williams, I think that there is some real problems for the state. Now, interestingly, it's an interesting take on these two cases, because both basically said, in both cases, Williams and Lewis, the defendant was found guilty, and the court found no error in either case, or at least no prejudicial error in the case of State versus Lewis. But I think if you read these two cases together, it really creates a problem for the state using this post hoc DRE expert testimony in terms of there being anybody able to give an opinion of impairment. So I'm not going to go through the facts of State versus Lewis. Go check that out. But effectively, what the court found when it came to expert testimony, I'm just going to read from this for just a moment. Based on the plain language of North Carolina General Statute 8C-1, which is our expert rule 702, officer laws could not testify that defendant was under the influence of one or more impairing substances and the category of such impairing substance or substances, because he did not hold a current certification as a DRE. And again, it references that statute as well as the rule. Moreover, the statute did not allow officer laws to testify as to the specific substance he believed was causing defendant's impairment, only the category of the impairing substance or substances. We conclude the trial court erred in allowing this testimony. However, defendant has not shown the error was prejudicial where Officer Miller, a certified DRE, offered similar testimony as to his opinion regarding defendant's impairment and the category of substances he believed was impairing defendant. So again, this is a situation where what the court says is that the charging officer, in this case, Officer Laws, could not testify that defendant was under the influence of one or more impairing substances and the category of such impairing substance or substances. So if you're not a DRE, you don't get to give an opinion that a suspect is under the influence of one or more impairing substances or the category. But critical to our conversation today is you don't get to offer an opinion about the defendant being under the influence of one or more impairing substances. So with that, again, that's a pretty straightforward rule. It doesn't matter if you have basically no training in terms of detecting impairment, whether alcohol or otherwise. Doesn't matter if you're A-ride certified. If you're not a DRE, you don't get to testify, according to State versus Lewis, that the defendant was under the influence of one or more impairing substances and so therefore give a opinion, expert opinion about the impairment or about the category of impairing substances. So that is State versus Lewis. Now, and ultimately the court found that was in fact error for that to come in, but again did not find that it was prejudicial error given all of the other facts in that case, and so upheld the conviction, but again did find it to be error, just not prejudicial error. So what comes out of State versus Lewis, and as I said back on episode 167, is a very valuable finding that if you don't have a DRE, you don't get to offer this opinion. Now, interestingly, in State versus Williams, again, this case was published today. It was decided here based out of Buncombe County, and so in State versus Williams, driver is observed by two Black Mountain Police Department officers. They see bad driving. They indicate that defendant was, upon stopping him, leaning up against his vehicle. He was confused, had very delayed responses, and his attention wasn't on the officers. He was lethargic, disoriented, confused, and had real soft slurred speech. Wasn't able to understand instructions for the HGN, exhibited every clue on the walk and turn test, wasn't able to complete the one leg stand. So based on all of this evidence, they had seen an open container in the car and asked the defendant to blow, and the defendant blew zeros. So these two officers that were not DREs, once the test had come back negative for alcohol, the court found that officers thought defendant may have a cognitive impairment instead of being intoxicated. So I'm assuming that's what the testimony came out as. Again, it's not really clear how the court comes to this conclusion, but it indicates that the officers, after the test, the PBT came back negative for alcohol, thought defendant may have a cognitive impairment. However, they continue searching the defendant's vehicle. They find 15 white pills. Pills were not labeled. When asked about the pills, defendant stated that they were his prescribed Percocet. Upon defendants giving that answer back, one of the officers, Officer Moore, formed his opinion that based on the totality of the circumstances, the defendant had consumed a sufficient amount of impairing substance, specifically the pills located in his truck, to impair his mental and physical faculties. Hey, podcast listeners, I want to briefly interrupt today's episode to invite you to join me at the inaugural Freedom Fighter Summit in Asheville this October. This in-person only event is designed for growth-minded lawyers determined to take their criminal defense practice to the next level. Due to the size of the summit's venue, there are a limited number of seats available. Don't miss out on the incredible lineup of speakers and spectacular networking opportunity that this summit provides. For more details, visit www.miniclaw.com/summit. Enter the promo code NCDWIGUY, all lowercase, all one word, at checkout for $150 off your summit ticket. Look forward to seeing you there. Now back to the show. Again, I don't know how much of this testimony came out at trial. And at the time that State versus Williams was tried, State versus Lewis had not yet been decided. That had not come back from the Court of Appeals. But again, it appears that Officer Moore, who is not a DRE, did give some opinion as to the defendant being impaired by an impairing substance, specifically Percocet, effectively. Again, I'm reading that into the opinion, so I could be mistaken about that, but that's what it appears to be related to. The defendant was taken in for a blood draw. ultimately, impairing substances come back in the defendant's blood. He was found to be dozing off when he was taken before the magistrate, but there's no DRE involved at all during the investigation or post-arrest immediate time frame. At trial, you have the two officers testify from Black Mountain. You have the state SBI lab analyst come in and testify about what was found in the defendant's blood. And then you have a DRE, again, that was not involved in the initial investigation, come in and offer testimony based on effectively what was done at the time of the arrest. This is Lieutenant Ann Fowler with the Asheville Police Department. Officer or Lieutenant Fowler was clear on multiple occasions that she could not testify to an opinion of impairment. She could not testify to an opinion of impairment. That is stated several times during the opinion. And so Lieutenant Fowler stated that she had reviewed the toxicology report, the body camera footage, the incident report, and the driving while impaired report, the DWIR. She based on her expertise, review of the case materials and officer's testimony. Lieutenant Fowler testified as to possible indicators of impairment present, including defendant being unsteady on his feet, having constricted pupils, nodding off in front of the magistrate, his slow, raspy speech, and being drowsy with depressed reflexes. So again, effectively seemingly what the court says is that as a DRE, Officer Fowler at no point indicated that in her opinion, the defendant was impaired by any specific substances or by any substance, that she could not testify to an opinion of impairment. She was very clear that she could not give that testimony, but basically said, here's the symptoms or signs that I am seeing on the defendant from my review. Here are the signs and symptoms of this specific drug category and what you'd expect to see if somebody was impaired by this specific drug category, and then left it at that. Basically leaves it for, I guess, the jury to determine. Now, it's unclear if it was, again, allowed. I think it was allowed for Officer Moore to give his opinion that the defendant was impaired. And again, this was prior to State versus Lewis. But if you look at these two cases together, if you look at State versus Williams, where effectively the post hoc DRE reviewer is coming in to offer testimony at trial and basically says, I can't form an opinion as to impairment, but I can tell you, here's the signs that the defendant was showing, and here's what you would expect to see with this specific type of drug category. Basically, that feels like an opinion. But again, if there is no opinion being given, which is what is pretty clear from State versus Williams, and the officers on the ground at the time under State versus Lewis are not permitted to give an opinion, there's nobody at trial with these two. If we move into a new case that is getting charged tomorrow, between these two kind of situations where, again, you've got no DRE involved, DRE offers testimony at trial, officers on the ground under State versus Lewis on a drug impaired driving case that are not DREs cannot give an opinion of impairment. And then you have the DRE coming and doing this post hoc review saying that they're not allowed to testify to an opinion of impairment. So nobody's giving an opinion of impairment. So the 2-minute long leading question of, Officer Fowler, Officer Smith, did you form an opinion satisfactory to yourself as to whether or not the defendant's mental and or physical faculties had been appreciably impaired to the extent that it caused appreciable impairment with their mental and or physical faculties, whatever the ridiculous long leading question is that apparently is not a leading question and is allowed to be asked at every single trial, regardless of what level that it's at. But effectively, everybody that is answering that question at a trial should be given the answer, no, I was not able to form an opinion, right? Because again, officers on the ground aren't allowed to do it under State versus Lewis. And again, reviewing DRE, very clear in the State versus Williams report, despite having the toxicology report, the body camera footage, the incident report, the driving while impaired report, basically everything necessary to kind of fully review this case basically is very clear. I can't give an opinion of impairment because they weren't there. They didn't do a DRE evaluation. They weren't there on the ground at the time, couldn't meaningfully investigate, so they couldn't give an opinion of impairment. So given these two cases, no officer, whether it's the charging officer, the officer that transports to the jail, the DRE that comes in to testify months or years later afterwards, nobody can give an opinion of impairment. And the crazy thing is, in a case like this, and again, there's a lot of evidence of impairment, it seems, in State versus Williams. But if you look at the officers on the ground, after seeing all of these signs and indicators of impairment, field sobriety tests, weird responses, strange speech, all of these things, they'd seen an open container of alcohol in the console. They do a PBT. It comes back negative for alcohol, and the officers think defendant may have a cognitive impairment instead of being intoxicated. That's after seeing all of these signs. So what does that mean? What does that mean about whether or not the person is impaired? From the officers on the ground perspective, we don't know. We don't know whether the person is impaired or not. Maybe they just have a cognitive impairment. That is why it's important to take such a person in front of a DRE who can then do an evaluation and offer an opinion of impairment. Officers on the ground don't get to give an opinion. The DRE that's doing the post hoc review, giving post hoc testimony, doesn't get to give an opinion of impairment. And so nobody gets to say, we think this person was impaired, despite all of the kind of physical signs or indicators of impairment. Nobody is offering that opinion. And so I think that this is something that is either an inconsistency with State versus Lewis and State versus Williams, or it is something to very much be drawn out in the future. Because again, I believe that Officer Moore, who's the boots on the ground officer in State versus Williams, was allowed to give his opinion testimony as to whether or not the defendant was impaired. Again, it's not clear from the opinion. So again, that's more of an assumption, but there appears to be an inconsistency because effectively with these two opinions, nobody's allowed to give an opinion as to whether or not the defendant is impaired. And if nobody's allowed to say it is our opinion that the defendant was impaired, then effectively this shouldn't even get to the jury, right? This should not survive a motion to dismiss. At the end of the state's evidence, if no officer is able to say, we think this person, was impaired, it's our opinion that the person was impaired. If the answer to the question, did you form an opinion satisfactory to yourself, blah, 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 is answered no, then it shouldn't survive a motion to dismiss. So again, this is something, and I believe that it appears that defense counsel in both of these cases did a very good job arguing that the kind of expert testimony should be kept out that there was no reason to admit that. I mean, one of the arguments that was made in State versus Williams at the trial level by defense counsel was that what is the relevance of the DRE's post hoc testimony if the officer is saying, I can't state an opinion of impairment? Basically, that is evidence that seems to be either A, irrelevant, or B, worse, designed to confuse the jury. I mean, there's no, if you've got a expert that can't give an opinion about something, that you go through all of this qualification and time and energy to get this person admitted as an expert, and ultimately they say, I can't form an opinion about whether or not this person was impaired. The boots on the ground can't form an opinion about whether it's impaired. It just seems like it is designed for confusion. And I think that defense counsel in State versus Williams pointed out the irrelevant nature of that type of testimony seemingly very well. But this is something that we really need as a defense bar as a whole to push. We really need to push this issue, because ultimately, if a DRE can be used post hoc by the state, then what would be the purpose of having more than 4 or 5 DREs statewide? If they don't have to do a boots on the ground investigation, they can just come in and look at the officer's notes and body camera and then give their post hoc testimony later at trial. Then why would the state put DREs more than 4 or 5 through this training? Just, have a regional DRE, let them be called in just like lab analysts at trial to offer their opinion about specific situations. That's really where this is moving towards, if you're not going to require a DRE to do their evaluation in real time. There's a real issue, a real problem for defendants in a thorough and fair investigation if there's no DRE getting utilized boots on the ground in real time. So again, I've kind of mentioned this in the episodes that I mentioned prior, episode 144 and episode 167. But if you have a post hoc DRE expert, make sure, and they're allowed to testify over your objection, make sure that you go through very clearly what their evaluation typically looks like. If they're able to if they're doing a DRE evaluation at the time of the arrest, what that 12-step evaluation looks like, the different signs and indicators that they are looking for, why it is important for a DRE to go through the amount of training that is required, the places in the manual where it says that a DRE should be called and utilized, particularly where the boots on the ground officers do not try to contact a DRE. All of these things are really important to put out there in front of a jury that is deciding this type of case, because effectively it's just showing that the state isn't trying to do the investigation correctly. We will let officers that should not be doing a drug evaluation, a drug impaired driving investigation, do that in real time, and we'll fix things at trial by having a DRE come in when the boots on the ground can't distinguish whether or not this is a cognitive impairment or a drug impairment. There's no ability to distinguish between these two things, between being intoxicated and having a cognitive impairment. We'll fix it afterwards by having a DRE come in, kind of compare, signs and indicators that the defendant was exhibiting with a specific category of drugs. Again, they won't give an opinion as to whether or not the person was impaired, but we'll try to fix this afterwards. Showcase how important it is for the DRE to be giving their evaluation in real time. When the DRE program was created, The purpose of the DRE program was not to create experts that could be used at trial to cover the tracks of officers at the roadside that did not know what they were doing when it came to a drug impaired driving investigation. The purpose was so that a DRE, a drug recognition expert, could be used in real time at the point that the person charged was being investigated. That is the design. It's basically for a non-alcohol related impaired driving case to have somebody that can come in and do a meaningful and fair roadside investigation. So again, if you do a lot of DWI cases, if you see drug impaired driving cases, you got to be familiar with State versus Lewis and State versus Williams. These are incredibly important cases. Again, both unpublished. This is an incredibly important place for us to take a real stand as a defense bar when it comes to the utilization by the state of a DRE at trial, and where there is this kind of post hoc push to use DREs basically to review a non-DRE roadside and jail investigation. We really have to push hard on these issues and protect the rights of citizens of North Carolina and visitors to the state. Hope this information has been helpful to you, and I look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.